The ruling is ready, and it is constitutional petition number E024 of 2022 in the matter of Honorable Kawira Mwangaza, the petitioner, in the County Assembly of Meru, the first respondent, and the Speaker, County Assembly of Meru, the second respondent. It is a 20-page ruling, but I'll only read the analysis and determination as follows. That I've considered the affidavits on record and annexures thereto, the preliminary objection dated 25th of November 2022, the written submissions and numerous authorities filed on behalf of the parties, and oral submissions made by Mr. Mutuma, Landed Counsel for the petitioner, Mr. Dionkolu and Mr. Mawira for the respondents. The court's jurisdiction to grant conservatory orders is anchored under the provisions of Article 23(3) of the Constitution and Rule 23(1) of what is commonly known as Mtunga Rules. And conservatory orders are aimed at preserving the substratum of the matter pending the determination of the main issue in dispute. And given the interlocutory nature of conservatory orders, courts are bound to exercise caution when dealing with any request for conservatory orders. And flowing from the above, a party such as the petitioner who alleges that her constitutional rights are threatened with violation is within her rights to seek the relief of conservatory orders. And for that reason, I hold that this court has jurisdiction to interrogate any act said to be undertaken pursuant to the provisions of the Constitution, and if necessary, invoke the powers under Article 23(3)(c) and issue an appropriate conservatory order. Consequently, I will consider the issue relating to threatened violations of the petitioner's rights and issues of merits, demerits, veracity or falsity of the allegations outlined in the impeachment of the Assembly, which shall be left to the Assembly and the Senate, which are the organs mandated to drive that process. In the instant case, the petitioner asserts that failure by the respondents to follow Standing Order number 65 of the County Assembly of Meru has resulted in the violation of our rights under Articles 47 and 50 of the Constitution. Standing orders regulate the County Assembly's procedure and in particular the proper conduct of its proceedings. The first respondent standing orders were exhibited in court, and I have considered those standing orders, and from the material placed before the court vis-a-vis the standing orders, order number 65, it is not disputed that the Deputy Clerk's letter dated 21st of November, giving the petitioner 5 days to respond to the motion, contravenes the standing order on two grounds. First, the Deputy Clerk or the Clerk has no jurisdiction to issue notice calling for impeachment of the Governor. Secondly, even if for argument's sake the letter was to be taken as notice, it contravenes the standing order for not giving the petitioner 7 days notice and has the effect of violating her right to a fair administrative action under Article 47 and denying the petitioner adequate time to prepare her defense in contravention of Article 52(c) of the Constitution and Standing Order number 65(2). There is evidence that the proposed motion of impeachment was placed on a notice paper on the 29th of November 2022. A notice paper under the provisions of a standing order means the official schedule of business intended to be transacted by the Assembly during a particular week, which can be equated to a weekly course list, whereas an order paper is the paper showing the business to be placed before or taken by the Assembly on a particular date. In this matter, there is no evidence that the proposed notice of motion was either placed on the order paper and debated before the debate on the motion of impeachment was scheduled for the 30th November 2022. And consequently, I find that the letter by the Deputy Clerk dated 22nd of November 2022 Inviting the petitioner to appear before the Assembly on 30th of November also violates the standing orders and was issued unprocedurally. I would have expected the respondents, and especially the Deputy Clerk, who saw the replying affidavit to this application and who is a key player in the process of impeachment of the Governor, to demonstrate by evidence that the Assembly had complied with all the provisions of Standing Order number 65 in every detail, but this did not happen, and the allegations of contravention of the petitioner's rights is therefore not challenged. And whereas an inquiry showed that the County Assembly had been operating, where an inquiry shows that the County Assembly has been operating within the constitutional scheme of devolution and running its legislative processes within the ordinary safeguards of the separation of powers, there would hardly be any scope for deployment of the court's conservatory orders. But from what is stated herein above, I find that the petitioner has demonstrated denial and violation or infringement of or threat to a right of fundamental freedom. And flowing from the above, the petitioner urges the court to grant conservatory orders as listed in the motion. The respondents have urged the court that in the event the petitioner is right, the court should invoke the provisions of Article 23 of the Constitution, by what learned counsel refer to as fashioning an appropriate relief in the manner of additional steps that the Assembly needs to take to ensure that the impeachment motion proceeds. The jurisdiction of the court under Article 159(3) is limited to interpreting the law. There are numerous rules of interpreting a statute, but the most important rule is the one dealing with the statute's plain language. And in considering the appropriate orders that merit this application, I'm guided by the principle that a party such as the petitioner is not required to suffer illegality or breach of her rights and resultant injustice on the solace that her grievance would be remedied either by the Assembly or by the Senate. It is the singular authority of the court to deal with threatened violations before they happen and to give appropriate relief, including conservatory orders in terms of Article 23(3) of the Constitution. On the other hand, this court is mandated to exercise restraint to guard against judicial emasculation of constitutionally ordained accountability mechanisms and processes that may have the effect of unnecessarily interfering or hampering the Assembly's oversight role. And upon considering the application and the preliminary objection, and after hearing the presentations of counsel, this court finds that the procedure adopted by the respondents to process the proposed motion of impeachment of the petitioner is flawed and has the effect of violating her constitutional rights. And under the powers donated to this court by Article 23(3) of the Constitution, it is therefore hereby ordered that the impeachment motion dated 21st of November 2022 by members of the first respondent scheduled for debate on the 30th of November 2022 at 10 a.m. is flawed and is quashed. A conservatory order is hereby issued prohibiting the respondents from discussing, debating, or in any way whatsoever dealing with the impeachment motion against the petitioner scheduled for debate today at 10 a.m. Courts shall abide the outcome of the petition. And in conclusion, I thank counsel for their robust participation by oral and written submissions given the limited time available to them. Those are the orders of the court.